Hello, good morning, good afternoon, and good evening, depending on where you are watching this from. I want to appreciate you and welcome you to another exciting edition of the Immigrant Survival Show with Ope Banwo and team, or and co, if you like. I have with me Grace Okafor tonight, who's a paralegal in our law firm, and we have Mr. Samuel Okpon, one of our senior paralegals, also here, who are going to be doing the show with me tonight. As always, we hope to bring you a life-changing event that will not only educate you, but brief you about what is going on with immigration in America, because immigration is always changing. When we come back, we're going to get the show started on the right footing. But first, here's the Rottweiler. My name is Ope Banwo, and they call me the Immigration Rottweiler. Not because I bark, not because I make noise, but because I don't let go. When your case gets tough, when the system pushes back, when others start telling you there is nothing we can do, that's when you call me. Because once I lock into your case, I don't stop, I don't quit, and I don't back down until we get results. So go book a consultation on speakwithope.com now, and let's activate the Rottweiler mode on your case before the immigration knocks on your door. All right, we are back, and of course, as usual, we're going to start tonight. I'm going to put Grace and Samuel in the studio for a minute as we go. We start out tonight, as always, with the immigration advisory of the week, because I think the most important part of the show is for you to understand what is going on, or rather to get an advice about how your case can be better for the day. So we're going to start out with the immigration advisory of the day. Right? Let me get that right there. I'd like to put some of it on the system for you. So we're going to start out right out where I think many of you tonight will really be interested in knowing what is going on with your system. We want to talk about some of the latest advice that I'm giving to people generally, because a lot of people get into trouble because they are not prepared for the season that we have found ourselves. So we're going to start with that, which is the advisory of the day. And I'm going to say my advice of the week is for you not is going to be for you not to wait until immigration. Where's my stuff here? I'm trying to get my write up here. Blah, 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 blah. Okay. For you not to wait until immigration tells you what you have missed, because once you miss it, it can become a major issue for you. Immigration rules are changing quickly and fast, literally every day. And one of the biggest lessons from this week's development is very simple. I'm going to encourage you, as my advisory of the week, for you to be proactive, not reactive. Be proactive, not reactive. With immigration now, they're able to deny what I call a certain incomplete request without first issuing an RFE for you. In other words, before, when you file something that immigration doesn't like or they don't feel is complete, they issue an RFE. But now they are telling you, as I'm going to discuss in the updates of the week when we come after this, they are able to deny without even issuing an RFE yet. And with major changes affecting a birthright citizenship that Trump is bringing all the way back again, TPS, asylum-processing, airport enforcement, where now they have eyes at the airport where they can actually arrest you on your way out. Before, America don't care when you are leaving. They only care when you are coming. With all of that happening, with foreign worker grace periods getting reduced and the ICE enforcement going on a whole new level, immigrants cannot afford to rely on yesterday's rules. So you need to be proactive. That will be my first advice for you this week. Know how the current rules affect your case before you make your next move. Before you file an application, make sure you have the required evidence. Review your immigration history for inconsistencies. Don't assume immigration will give you another chance to fix something that is not strong enough. In other words, they're not going to give you opportunity to fix a weak filing. If you have TPS or any other temporary immigration protection, know when your protection ends. Determine whether another immigration pathway may be available. Don't wait until they've been talking about withdrawing TPS for Sudan and all these other places. You need to determine when another immigration pathway may be available for you. Don't wait until your status is about to expire before you make a plan. If you are one of those who are seeking asylum, prepare your case carefully from the beginning. Because once it's submitted and they're calling you for interview, it's almost too late for you to make major changes. Keep your story and your evidence consistent. A lot of what we are seeing these days is people and what they submitted to immigration and what they are saying when they are interviewed are two different things, because they didn't ensure that they are consistent with their story and the evidence. You need to also understand how recent asylum processing changes could affect your case, because even asylum, the processing is changing. If you're a foreign worker, monitor changes affecting your work authorization and grace period. If you're a foreign worker, know exactly when your immigration authorization and lawful status expire. You must know your I-94, not the visa you got on your passport. If you're a foreign worker, don't rely on assumptions about how much time you have. It is changing. If you are traveling, understand the potential immigration consequences of your trip before you leave the US. You need to carry appropriate documents. And of course, one thing that a lot of people are missing, they don't talk to immigration lawyers until it is virtually too late. And that to me is probably one of the biggest mistakes people are making right now. Because if you don't talk to immigration before your case becomes a crisis, by the time you finally get an immigration lawyer, if you don't talk to an immigration lawyer before your case becomes a crisis, by the time you finally get a lawyer, it may be too late. There may be nothing they can do for you. So for those of you who may potentially have problems with immigration, the best advice I can give you this week in this immigration advice of the week is make sure you talk to a lawyer before it becomes a crisis. Consulting with a lawyer before you have problems probably will cost you $100. That's what I charge for consultation. Some charge $200, some charge $250. But whether it's $250, whether it's $200, whether it's $100, whether it's free, some lawyers even do free consultation. Spend that time, spend that money to do consultation about your case before you get into crisis. Because when you're in crisis, maybe you have been arrested or they've sent you a letter that they want to deport you, nobody will be talking to you for $100. They're going to ask you to put down like $5,000 down before they talk to you. If you are lucky and you get a nice lawyer, maybe it will take $2,500 from you to start. And they will charge you like $10,000, $20,000, $15,000, $7,500. To solve a problem you could have ended off with just $100 consultation so that you know where you are. And if there's something to be done before immigration comes to your door, you're already doing it at a much cheaper cost, because you can talk to a lawyer for that just $100 consultation fee and then decide that you're going to go handle your case yourself once they've advised you what you need to do, what you need to file. You can save yourself a lot of money with that if you don't even want to hire a lawyer. But once problem has come, nobody's going to have mercy on you like that. Even if they're going to have mercy, they're going to charge you, including me. I'm going to charge you my rates because now we are going to war for you. You have to pay for that war. But before the war comes, if you come to see me, it costs you only $100. Or you go see another lawyer, maybe it costs you $200. Or find one that is free if you don't really want to pay any money. But either way, find a lawyer if your status is not solid yet. You're not yet a citizen. And you think, or maybe your status is expired, or it's expiring, or you have a criminal case and you don't know if that's going to affect you or not. Now they can take your citizenship if you have some if you make some mistakes. They are taking citizenship. They can take your green card if you have a criminal case. So you don't wait. You don't say, oh, I've disposed of my criminal case. You go and plead to whatever you like because they tell you there will be no jail time. You plead, and then you are surprised 1 month later, immigration comes to arrest you and they want to deport you and take your green card, because there are immigration consequences for every plea that you do now. You need a lawyer. And that is my advisory for this week. Do not wait for immigration to tell you what you missed or what is wrong with your status. Better for you to figure it out before they come for you, and then for you to start looking for solution before it becomes a serious problem. That is our advisory for today, and I hope that will help you, or you will listen to me and begin to take action on your case. 1 second here. So if you have any questions on what I've said, all you need to do is contact us at banwolaw.net. Go to our website, or you can book a call at banwolaw.net/consultation and talk about that problem before it becomes a big problem. Before we take the update, we have done something to also make sure we assist those who may never be my clients or who may want to be updated on what is going on about American law right now. I've created the Banwo Law newsletter, where every month we actually put together all the developments in immigration for the month. We have some advisories in there. We have some tutorial lectures in there where you can keep yourself abreast, and it's 100% free. It's like having retaining a lawyer without paying any money. So you may want to sign up for that newsletter right now. banwolaw.net/newsletter. banwolaw.net/newsletter. With it, you can get updated on a weekly basis, literally, on what is happening with America. But here is a short video that explains what the newsletter is all about, so that you can go download and you can go subscribe right now for free, 100%.
Stop! Before you file another immigration application, before you renew your work permits, before you attend your next deportation hearing, before you travel to the USA, before you listen to another immigration expert on social media, you need intelligence, not guesswork. Every single week, American immigration laws change. New policies are announced. Court decisions shake things up, and one wrong move could cost you your visa, your green card, or even your American dream. I'm Attorney Ope Banwo, better known as the Immigration Rottweiler. For almost 30 years, I've been fighting for immigrants across America. Now I'm putting that experience to work for you free. Introducing the Banwo Immigration Newsletter, your monthly immigration intelligence report. Every month you'll receive the biggest immigration stories you must know, a powerful masterclass that breaks down one complex immigration issue into plain English. My famous Rottweiler's immigration tips to help you avoid expensive and heartbreaking mistakes. No legal jargon, no politics, no fear. Just practical immigration intelligence from someone who's been in the trenches for nearly 3 decades. And the best part? It won't cost you a penny. So don't let ignorance become your biggest immigration problem. Subscribe today at banwolaw.net/newsletter. Stay informed, stay protected, stay one step ahead.
All righty. Welcome back to the Immigrant Survival Show with Ope Banwo. The next, we're going to go into the major immigration updates for the week that we always start our show with, which is to let you know what are the new developments, because in immigration of today, things are moving rapidly. Things are happening. Literally, you wake up in the morning, something else has happened. And this is the part of our show where we keep you abreast of the development. So we have several of them because we didn't have our show last week. We want to make sure we catch you up on all the ones you have missed. So we have several of them. I'm going to quickly go through them, and hopefully if you have any questions as I go through them, please feel free to put your questions on the chat wherever you're watching this. Okay, I'm not live on. I thought I was live on Instagram. I was. 1 second here. I'm getting texts in saying that they are on Instagram and they are waiting for us to go live. So let me quickly do that before we go on with this. I hope I can figure it out now that I'm live. I don't know. Sorry about that. Instagram people, we are going to be going live in a second. Okay, I guess we are not going to be live tonight here. I'm trying to work it, but it's not, for some reason, it's not working. But that's fine. You can watch the recording later. So let's get to the immigration advisory for the week, the updates. The first update is, I'm sure some of you have already started reading about it in the papers, is that immigration can now deny some cases without sending them an RFE, without asking them to submit additional information for their case. In other words, what exactly is this update? The immigration has issued a new policy guidance from October 5th, giving immigration officers broader discretion to deny applications, to deny petitions and other benefit requests without first issuing a request for evidence or a notice of intention to deny when a required evidence is missing or the record does not show eligibility. And now, so that you understand, this is not a proposed rule, this authority applies immediately, including to pending cases. Immigration says the purpose is to discourage incomplete or placeholder filings and to place the burden squarely on applicants and petitioners to prove their eligibility as at the time they file. So that you understand what this is, I will try to repeat it in different ways for you. Now, before, when you file a petition with immigration, let's say it's missing a document or you didn't properly explain one part of the criteria to them, what they typically would do is they will issue what is called request for evidence, or they might even send you something called notice of intention to deny, that we have looked at this thing, we are likely to deny it because of this, because of that. And then they will give you like 30 days or 60 days, sometimes even 120 days to supply additional information if you don't want them to deny the case, or to supply what they think is missing. Sometimes what is missing might simply be, or they say your doctor's report that you submitted, that they don't like it, you need to submit another one. It could be that you did not submit passport photograph. It could be something as simple as that. They send you a request for evidence, you send it in. But now the new rule is saying they don't have to do that anymore, that they can deny the application just because it was not complete when initially filed. So why does this matter to immigrants? Many immigrants have traditionally assumed, including lawyers, that if something important is missing, immigration will simply send them an RFE and then give them an opportunity to fix the case. That assumption is now very dangerous. A poorly prepared green card application, application for a visa, application for waiver, application for employment authorization, or other immigration filing could potentially be denied without a second chance being given to you to supply the missing evidence. And this is a serious matter, especially for many of us who file our applications ourselves because we don't have money or we don't want to pay lawyers or whatever. Okay, so here is my strategic recommendation here. Whether you're filing by yourself or you're filing through your lawyer, treat your first filing as potentially your only filing opportunity. You're not going to get another one. You have to treat it as your only filing opportunity. So before you submit, to immigration, make sure that all the required initial evidence is included, double-check signatures, double-check forms, double-check fees, double-check supporting documents, because if any of that is not complete, they can deny your application without sending you an RFE. I've had people before, for instance, where like one of the files shown to me from another lawyer today, they filed a VAWA application for this client, but they omitted a complete part 10 of the form. But immigration didn't just deny the application right there. They send them what is called an RFE for them to complete the part 10 and submit only that page, which is page 14 of the application to them. If it is under this new rule, they'll just deny it outright without any discussion. So you want to double check your signatures, your forms, your fees, and your supporting documents. Do not file a weak or incomplete case simply to get something in, because a lot of people do that, even lawyers, including me. Sometimes when all the documentation is not in and you are running out of time, you tell the client, let's just put something in. When they request for evidence, we supply that. That is absolutely dangerous now. Do not file a weak or incomplete case simply to get something in. Make sure you get everything that you need to submit in at the time you are submitting it, or you may just be wasting the filing fee for your client. For complicated cases, you should have qualified immigration lawyer review the package before submit. If you are telling yourself, I want to save money, I'm going to do it myself, what is going to cost you may be a lot more than money. Not only will it cost a lot more money when they put in proceedings, it will cost you anxiety. It will cost you a feeling of I'm about to be deported. It will not give you rest. Those cost you more than money. Those affect your health. When you're in deportation proceedings, you don't sleep well. And you can avoid all of that by using a lawyer from the beginning, or getting a lawyer to help you review. If there are lawyers who do that, I typically will not do that for. If you feel it yourself and you just want me to review, I'm still going to charge you my full fee. But there are some lawyers that will charge you less just by reviewing your application for you. It's still better to pay them a little money to review your application for you than for you to go file it yourself, and at the end of the day, a problem comes. Bottom line here, immigration no longer gives you a warning before they deny a deficient case. They said so. So the era of file now and fix it later when the RFE comes just became much more dangerous, because they don't have to do it anymore. They might still do it for some, but the rule is saying they don't have to do that. They can deny it outright if anything is missing. For instance, your mother is filing for you, and then maybe when you submitted, you didn't submit your birth certificate, or you didn't submit the birth certificate of your mother to show that it's your mom, to match the names. And that happens a lot. It don't matter that you're a U.S. citizen. It don't matter that you are qualified. They're going to deny it. Or you are filing through a U.S. citizen spouse. You are saying, I'm married American citizen. Maybe it will be automatic. No, nothing is automatic now. If you forgot to put his birth certificate, or you forgot to put a disposition record, your application can be denied outright. That is the update number one I want to make sure I shared with you. That I started about 2-3 weeks ago. But in case you are not aware of it, you need to know that. Update number two that I would like to share is that Trump has signed a new executive order targeting birthright again. Yes, you thought it was over. We all celebrated. We all threw a party. But this past week, Trump has signed a new executive order targeting birthright citizenship and birthright tourism. In fact, they signed two of them, two executive orders on August 6th, targeting specific situations involving U.S. birthright citizenship. After losing at the Supreme Court, it's coming back. Now, the administration is directing federal agencies not to recognize automatic citizenship in a narrow category. I get it, because the Supreme Court already said it cannot stop that. Now it's coming as some narrow categories, including some children born to foreign government representatives, members of designated terrorist organizations, or who are designated as alien enemies, and situations involving alleged fraud or commercial arrangements that is designed to specifically obtain U.S. citizenship through childbirth. In other words, if you paid somebody or there's commercial arrangement, that is designed to allow the person to come here and give birth, they're not going to give you. If you have been designated as a member of a terrorist, if your father has been designated as a member of a terrorist organization, and they give birth to a child in the US, the child is not going to be automatically an American citizen. And if you're a child born to foreign government representatives, children of ambassadors, children of foreign representatives, you don't get American citizenship when you are born here now. And then a second executive order that I issued on the same day, August 6th, specifically targeted birth tourism. That was traveling to the US primarily to give birth so that the child can obtain US citizenship. They're saying they're not going to give your child automatic citizenship anymore. Now, this is a little bit different than the argument he had before. Before, it's like everybody whose parents are not legal. When you are born here, you don't get citizenship. The Supreme Court clapped back at him and said, no, you cannot do that. It's a constitutional right. Now it's coming back and naming some specific things, basically saying that your parents are committing criminality before they give birth to you, so you are not getting the citizenship. It's important to separate them. This is not a general end to birthright citizenship. Trump is now targeting specific areas that he believes Supreme Court will agree with him. Obviously, people are still going to take him to court. Okay, the Supreme Court recently rejected the administration's earlier, much broader attempt to deny citizenship to children simply because their parents were undocumented or temporarily present in America because they have a B1, B2 and temporary. Is trying to deny citizenship to that. That was the first round. These new orders is attempting a much narrower approach. Of course, we know more cases going to come. Now, we immigration lawyers are not just going to accept it and go away. People are already filing lawsuits against it. But right now, that's the posture of America. And here's my strategic advice or recommendation here. Don't panic because of the headline saying Trump has ended birthright citizenship. Trump has not ended it. But foreign nationals traveling to America specifically to give birth should understand that the government is increasingly treating misrepresentation about the purpose of travel as a serious immigration issue. And it's saying that if you are come specifically just to give birth, your child will not have American citizenship. So my advice is never lie to a consular or immigration officer about why you are coming to the US. There is no law against coming to the US to have children. If that is your purpose, maybe you have complication, you need medical advice, blah, blah, blah. You need to tell the truth to the immigration officer, the consular officer. Don't tell them you want to go and attend your sister's wedding or your sister's party and you're already 8.5 months pregnant. You're planning to come here and have children. He's saying, your child is not going to get that citizenship. Now, of course, we know that there's going to be litigation on this, but I have a strange feeling that Trump will win on this one because he has read the judgment of the court last time and how and why they say he cannot stop it. Now it's coming in a narrower category that he probably believes they will back him on. I don't know if the Supreme Court will back him, but it's coming. Bottom line is, birthright citizenship remains the general rule in America. But the administration is trying to narrow its boundaries in specific circumstances because the Supreme Court already told him you can't do a general ban. That's constitutional. Now it's coming in narrow, specific instances and hoping that the argument will win. Now, I don't know how it's going to go with a Supreme Court, but know that another major constitutional fight is already starting over this. That is the second update. Have no fear, but know what is going on. I always say once you know what's happening or what's about to happen, you have a better opportunity to defend yourself or to be ready. Update number 3, and that may not apply to everybody because not every country has TPS, very few ones, but you need to understand that now the Supreme Court has cleared the way for the U.S. organization, actually it's the Court of Appeal, for Trump's administration to terminate the TPS for South Sudan and Myanmar. That's on August 7th also. Could have given this last week, but we didn't have our show last week. Okay. Federal judges, not Supreme Court this time, federal judges in separate cases, they've allowed Trump to move forward with ending TPS for people from South Sudan and Myanmar, which is Burma. I think that was a country that used to be Burma. They're now called Myanmar. And TPS, for those who may not understand what that is a humanitarian program that protects temporarily eligible nationals of countries who are facing war, disaster, extraordinary conditions. Okay, it protects them from deportation and generally allows them to work in the US while they are in that status. But it's a temporary protection. And now Trump is saying what is temporary cannot be permanent. You cannot be in TPS for 10 years or 7 years or 20 years. It has to end. So these rulings that we just got from the federal courts affect South Sudanese people and Myanmar nationals, over 4,000 nationals. The South Sudanese are not plenty. They're like about less than 1,000. Okay. For the affected individuals, losing TPS can mean losing protection from deportation. That means they can carry you now and deport you. And then you also lose your TPS-based employment authorization unless you have another lawful immigration status or another independent basis to remain in America. So you need to start thinking, what can I do to keep my status now that my TPS is being terminated? So if your TPS is being terminated, either with the latest ones or those that have been announced before, don't wait for the expiration date. If you have TPS, have an immigration attorney immediately review whether you have another pathway, such as asylum, family, or employment-based immigration, adjustment of status, or any other form of relief to take you out of TPS into a different status. Because remember, losing your TPS does not automatically mean you cannot get any other status. TPS is only a temporary protection. Now is the time to find out whether you have a plan B, not when you need it, when they start coming for you, because at some point, immigration will start rounding up those who have lost their TPS to get them out of the country. You don't want to wait for that before you start seeking assistance from lawyers. I'll be more than happy to consult with you. You go to banwolaw.net/consultation to book your call or find a lawyer near you. It doesn't necessarily have to be me. I'll be happy to consult with you on Zoom. If you are not in the Dallas area, I represent clients nationwide, globally. In fact, we can talk to you on Zoom and then figure out how we can help you. But if you don't want to do that, look for an immigration lawyer close to you, wherever you live. Go have that discussion before you need it. Because if you wait until the time you need it, it may already be too late. Now, let's look at update number 4. Now, this one is affecting a lot of people already in the US because, and I know that because I have lots of clients in this area. The update number 4 now is that US immigration can now send some asylum applications directly to immigration court. Now, what exactly is this update now? A major change to asylum processing now allows immigration, that's USCIS, to refer certain affirmative asylum application, that's the one you file before you get in proceedings, to refer directly to the judge. In other words, they put you in deportation proceedings immediately without first giving you an opportunity to interview for that asylum before an asylum officer. Before, and I went through this process, so I understand it. When you file an asylum application, what they do is that they give you an opportunity for an asylum officer to review your case, to tell your story to the asylum officer, to convince them why you should be allowed to stay in America based on persecution. And then many get their applications approved at the asylum officer level. But they are saying now, they don't want to waste time much with immigration officers now. When you file your asylum, they can send it immediately to the immigration judge for you to go and argue your case before the immigration judge. In simple terms, Many people who apply affirmatively for asylum while already in the US may find themselves before an immigration judge much sooner than they expect. That's the update. I don't like it, but don't blame the messenger. That's what is out there. So why does this matter? The asylum interview is what has traditionally given applicants an opportunity to personally explain their persecution claim and to answer questions before immigration on why or before immigration can decide whether to grant their asylum or to refer their case to court. Bypassing that step could mean faster placement into deportation proceedings and less opportunity to correct a weak or poorly documented application before you reach immigration court, which is why if you want to file asylum now, it's not something you do yourself. I'm begging you, if you're out there, it will look self-serving. Yes, it is self-serving for a lawyer to say that. Go get a lawyer to help you file so that you file a complete asylum application from the beginning. They can help you think it through, make sure that the grounds you are trying to claim qualifies, help you position your statements properly, because you might have a good story, but if you tell it the wrong way, you get denied. If you don't put the particulars that you need to put in there because you don't know better, even though you have a great persecution experience, you lose. Now you don't want to do it yourself because you may get only one chance before they send it straight to judge. Sometimes now. They're not saying all, but they're saying they can send it straight to the immigration judge if they feel they don't want to deal with it. So it is a very, very big development because lots of people ran to America because their life is in danger, especially from countries with violence and all that. You came in here because you're afraid for your life. And if you want to file that asylum, you better give it your best shot by making sure you hire the service of a competent immigration lawyer, not immigration consultant, not notario. Those ones are just going to fill form for you. So here is my strategic, the Rottweiler strategic recommendation here. Treat your asylum application as though an immigration judge will eventually read a word of it. That's how you prepare. Don't assume it's going to end at immigration office. Don't submit rushed or fabricated asylum stories. Document your asylum stories well. Make sure your declaration and evidence that they support each other. I've seen some funny asylum application brought here after they have been referred to the judge. What they declared in their statement is different from the evidence that they have. The evidence they even have does not support the story they're telling. You don't want to do that. A lawyer will check all of that for you. You want to explain inconsistencies before they become credibility problems. Don't just assume it will go away. Don't lie about it. If there's inconsistency in your story, it's better to let your lawyer explain it before it becomes a credibility problem, because asylum is about whether the judge believes you. Credibility is very important. It's critical. You can tell all the story in the world. You can have all the documentations in the world. If the judge says you are not credible, you lose. If immigration says you are not credible, you lose. And when there are inconsistencies that you are not explaining, then your credibility dies. It's better to recognize and admit the inconsistencies and explain them. If you know of it before you file, make sure it is addressed in your filing. If it comes after, don't try to be Superman. Admit it and then be ready to explain it. That's why you need a lawyer, whether before you file or if you have filed yourself before you go for interview. Get competent legal assistance before filing whenever possible. I'm begging you on that one. I've seen people with great stories lose out because they decide to do these things themselves. You can say, oh, he's just trying to get clients. You can say that. But those who know me know better. Know that I don't give advice based on you coming to hire me. I'm going to give you advice based on what can help you. You don't have to use me as your lawyer. There are plenty immigration lawyers now. Get a good one in your neighborhood, and you can thank me later. All right, let's look at update number 5 because we have so many of them. I'm rushing through some of them now, but I will still give you full explanation on every one. Okay, now immigration, the next update, in case you are not aware, I just went through this just 2 days ago with a client. Okay, I had this client who we negotiated a safe departure for because she's about to leave herself anyway. And immigration went to the house. They're trying to arrest her because of they have this thing for F1 now. For if you come in as an F1 and you don't go to school or you're not going to school fully, just be aware they've set up task force to come and look for you and come and arrest you and deport you. They put your name in a database anywhere, even when you are leaving the country, they will still arrest you because you have violated your status for so many years, and they make sure it is deportation you took out of the country. So if you get a deportation, you can never come back, right? I have heard that immigration actually go to the airport and they pick up people. Now, they are at the airport, but I witnessed it 2 days ago. So when my client was going, I said we had agreed I would go with the client. By the time I got there, guess what? The officer that was in charge of our case was already in immigration, was already at the airport. Not for my client, of course, because we had already sorted our own and we have our deal, and they always honor their deal. They are responsible people. When they give you their word, they typically we honor it. They were there waiting for some people. I never saw that. I didn't see them actually then arrest anybody because after I finished, I left. So I believe this is already happening. And I've got people who have called us after being detained by immigration at the airport. I have several clients I represent now who have been arrested at the airport. Some of them were let go, but they were put in deportation proceedings. And then they came to my office. So what exactly is this update really that I'm talking about? Reports indicate increased ICE enforcement activity at airports, including arrest of some non-citizens as terminals, check-in areas, and boarding gates. Terminals, check-in areas, and boarding gates. Because there is now enhanced information sharing between federal agencies, it can then make it easier. It has made it easier for immigration authorities to identify travelers with expired status, outstanding removal issues, or other immigration concerns. Imagine a client that has been ordered deported, but he hasn't gone. He maybe was ordered deported 3-4 years ago, but he didn't go. Finally, he decided he was going to be leaving. Maybe they will encourage him to leave. No, they will arrest him at the airport. If you have violated your status, before America don't care when you are leaving. They don't even stamp you when you are leaving America. America, if you are leaving, it doesn't come. It's when you are coming that is the problem. They want to be sure that you have the right papers, you are the right person to come in. But now they are behaving like Dubai. You know, in Dubai, if you overstay, immigration will hold you on the point of entry. If you owe money, if you have committed anything, they are waiting for you when you are leaving their country. And they are much worse for those of you who like to criticize America anyhow. In Dubai, if they allowed you to stay till January 30th, and you stay till December, that is not how you stay 1 year overstay, they're going to fine you for every day that you overstayed. It's not theory. It has happened to my in-law. They are waiting for you that they will calculate the money for you. If it is $20,000, you are paying that money before you go. You are not leaving the country. They will take you from there straight to jail until you pay that money. If you have something outstanding, they're going to be waiting for you. America is getting there. We're not there yet. They're not finding you. But I can predict we're going to be going there. So, you know, the Trump administration likes money. The next thing now is that if you have overstayed and you are leaving, it might say you have to pay a fine. It is coming. You already know if you can project how this administration works. I don't know what will happen with the next administration. No. Once eventually Trump is going to figure it out that it's a money-making opportunity, they're going to find you. Dubai is doing so. There is nothing unique there. Some other countries are doing that. I witnessed Dubai because it happened to my in-law. Okay? They will make you pay for every day that you overrun. I also have somebody who wrote a bad check, who thought everything was over. They complained about the bad check. He went and paid the money, and he thought it was over. When he was leaving the country, they arrested him. And they have a fine, automatic fine, for writing a bad check. You have to pay that fine. And it was a big fine. Or you are not leaving. They take you from there straight to the airport, to prison. But America is not there yet. But what I'm saying is that don't just think it's absurd. It's never happened before. It's happening somewhere else. But what they are doing now is that there's increased ICE presence at airports for those who are leaving. They've always been there for the coming in, obviously. But for those who are leaving now. So if you have an outstanding problem with immigration, don't just Go. Talk to a lawyer. Why does it matter? Now, let's talk about that. Many immigrants in America now assume that because they purchase a domestic airline ticket or pass TSA security, they are safe to travel. I am talking about even within America. You are going from Texas to Nebraska. They can stop you. And if your status is not solid, you are going to face arrest right there. They are the exit from the country. They are within the country travels to now. And you can be singled out just by looking at your face, the same way they used to single people, not ICE now, the same way security used to single out some people at random. I have been selected at random before for enhanced security check. They can just look at you, it's around, they pick you out of the line, and they go and do enhanced security on you, and then they let you go. ICE is doing the same thing too now. They can look at you, profile you, and say, let's check this person, whether it's a legitimate resident. So it is not really safe to travel even within the US on a domestic flight if your papers are not correct. Because TSA screening and lawful immigration status are two different things. Air travel can expose your identity and travel information to federal agents, which potentially creates additional risk for someone who is undocumented, who has overstayed, who has an outstanding order of removal, or who has serious immigration problems. So here is my strategic recommendation here. Don't automatically assume you cannot fly. I don't spread fear. I don't want you to be fearful of your life. After all, this is still America. There's still freedom here. So don't automatically assume you cannot fly. But know your immigration status before you travel. And like I advise all my clients, I'm advising you, if you are listening to this, I don't care if you have a green card. Carry proof of it with you. If you look like an immigrant and you are already a citizen, carry a picture of your citizenship passport or your naturalization certificate. It doesn't cost you anything to carry a copy. Because while you are busy arguing, I'm an American, you'll be in Mexico. We have seen them deport some Americans, some people turned out to be Americans because they have no proof to show that they're Americans. You got to carry your proof. So I'm not saying don't travel. I'm saying go with copies of your status. Know your immigration status before you travel. If you're out of status, then you want to have a talk with your immigration lawyer before you get on that plane. Whether it's from Louisiana to Nebraska or from Nebraska to Iowa, it does not matter. Now, if you have overstayed, I'm giving my strategic recommendation here. If you have overstayed or have an old deportation order, or you have missed an immigration court, or you are unsure about your status, speak with an immigration lawyer before traveling, especially before international travel. Don't tell yourself, well, I'm leaving their country now, why should they care about me? They care about you. And if you have been deported and you came back, for instance, and then you are trying to go, they can arrest you there and then prosecute you criminally for illegal re-entry. That one carries jail time. It's a serious matter, so you need to have a talk with your lawyer. The bottom line here is an airline ticket is not your immigration status. An airline ticket is not immigration protection. Don't say, oh, I'm leaving. Before you head for the airport, know your status, know your risk, and know your rights. And if your case is really serious, you may want to even ask your lawyer to go with you, so that if they have to contact immigration in advance to pre-negotiate your exit, so that you are not arrested. If you are really leaving anyway, so it might be something that ICE might be willing to say, okay, we're going to waive this guy, at least leaving, show us proof that you have left, and then they will let you go. You carry a lawyer, follow body. It has become like that now. Okay, just in case. All right. That is my update number 5 that I hope will bless some of you just watching this tonight. Update number 6. One thing that is also happening now. Okay. You know, immigration is Yeboah, I see your question. When we get to the Q&A, I'm going to take it. I see I don't know where you're watching. Oh, you are watching from LinkedIn. Kwado Yeboah. I see your question. All of you are posting questions out there. We're going to get to the Q&A session in a minute, and then we will take all those questions. Right now, I'm dealing with the updates, so I don't want you to feel that I'm ignoring you. It's because we are not there yet. Okay? All right, so let's look at update number 6. DHS is moving to eliminate the 60-day grace period for laid-off foreign workers. What exactly does this update mean? Okay. Immigration is not telling us. I like to use just the generic word immigration because people get confused between DHS, USCIS, ICE, BCBP, all that. So I'm not going to worry you with all of those technical different agencies. They are all DHS. They are all USCIS. They are all DHS. Okay, even though they are different departments. USCIS is separate from ICE. ICE is separate from CBP. So DHS, which is immigration, as I like to call them, is considering eliminating the up to 60-day grace period that normally gives certain workers, foreign workers, time to deal with their immigration status after they've lost their job. Okay, potentially affected categories will include H1B, L1, O1, TN, E1, E2, E3, and H1B workers. Now, before I further explain this has not yet taken effect. This is a proposed rule. It is still in the federal, what I call rule-making process. Every rule they want to introduce goes through a process. So they've just introduced the rule. It's not yet been implemented. So you don't have to panic yet about this. Just understand what is going on. Okay? You know, right now, let's say an eligible H1B person or L1 person or O1 person, okay, or other covered worker, if they suddenly lose a job, okay, they may have up to 60 days or until the employment, the authorized stay expires, whichever is shorter. In other words, until the I-94 expires or up to 40 days to find another employer or to change their status or to prepare to leave. Now, if that protection is eliminated, losing your job can become a much more immediate immigration emergency. That's why this matters. What this rule is trying to do is to eliminate that 60-day period that gives you the leeway to look for a different status, to change yourself. I've dealt with a lot of clients who have changed from EB1 to O1, who have changed from O1 back to EB1. From there, they've changed to E just to maintain their status because they have time. Now this rule is trying to eliminate that. So here is my strategic recommendation, as I always do with every update. If your immigration status depends on your employer, you need to build your plan B now before you receive a termination letter, especially if you start smelling that they may get rid of you. Know your I-94 expiration date. A surprising number of people do not know their I-94 expiration date. They are still relying on the passport, the visa on their passport. Know your I-94 expiration date. Keep copies of your immigration documents. Understand your alternative visa or green card options. You should be thinking of your alternative now. And speak with an immigration lawyer immediately if layoffs appear possible. Most times, layoffs do not happen overnight. You will be hearing the rumor, or the company itself may be saying it in meetings. And you are sitting down there with an O1 or L1 or H1B, and you are not making moves. Like they say in my language, I'm from the Yoruba tribe of Nigeria. We used to have a saying, which I will translate for you. They say, Ogun asotele, kokin paro. In other words, they used to say, a war that is pre-declared does not catch a cripple unawares. Because a cripple that knows it cannot run fast, when the war enters the town, it will start moving from the time they announce that war is coming, so that he can get out of town. Same way, immigration is telling you they are about to eliminate this. They have not done it yet. Don't misquote me. This is a proposed rule. So when you know that this is coming, your job now is to start looking for your alternatives. The 60-day grace period still exists today. I repeat, so don't panic based on headlines. But foreign professionals should take the warning seriously, like that cripple. When your immigration status is tied to your job, losing your job can put your immigration status at risk. Talk to a lawyer. Again, it always comes down to this. Know your plan B before you need it. It is always cheaper when you know your plan B before you need it. But if you are looking for plan B after plan A has failed and now immigration is looking for you, it is generally more expensive. Sometimes it is even impossible for anybody to help you at that time. And this one is some good news for immigrants. Immigration right now is moving to put body cameras on all field officers after all the stuff that has happened. Now, ICE themselves, they are proposing to put body cameras on all field officers. So what is this update again? ICE says it expects all officers and agents who are conducting field enforcement operations to have body cameras, one on their body, by the end of August is when they are proposing to start this. So the nationwide expansion means many ICE arrests and enforcement encounters could now be recorded from the officer's perspective so that we can see what the officer is seeing, why he did what he did, and why does it matter? See, body camera footage could become an important evidence when there are disputes about what happened during an immigration arrest, including allegations involving searches, use of force, statements made by immigrants, or the officer's conduct. A lot of cases could come out of that because you may even lose your status or they may deport you, but you may end up having a great case to sue them for serious damages. It could be a basis for courts to dismiss cases against you if they see what happened in the video. So this is good news in a way, but remember, a body camera records you too, not just the officer. So what an immigrant says or does during an encounter could potentially become evidence later. Think about that. What you said to immigration, the way you behave when they confronted you, could potentially become evidence against you later. It works both ways. So here is my strategic recommendation on this one. If ICE approaches you, stay calm. Do not physically resist, even if you are an American citizen now. Do not lie or provide false documents. They are recording it, remember? You can't change it later. Exercise your right to remain silent where applicable. If you don't talk, you can't get in trouble. You have a right to remain silent when they are trying to arrest you. Do not consent to searches because you feel intimidated. Because many times, unauthorized searches, illegal searches, will get all the evidence against you thrown away. So don't just agree for them to search you because you feel intimidated. It's your right to say you are not agreeing for them to search you. They don't have to search you if there is no immediate reason why they must search you. There are very important rules to searches in America, and you are entitled to that. And when they approach you, what you should also do is ask to speak with an immigration attorney. You don't have to volunteer any information. It's your right. You don't have to talk. It's your right. The only thing that can be coming out of your mouth is, I want to call my immigration lawyer, which is why you should always have the phone number of a trusted immigration lawyer in your possession, on your phone, everywhere. So that when they arrest you or you come into contact with ICE, you can call your immigration lawyer immediately and they can start driving towards wherever you are or ask to speak to the officer. It happened recently with one of my clients or proposed client. But they have the phone number of a lawyer to call who happen to be one who doesn't do immigration law as a call, is a personal injury lawyer. And that one called me. And I stepped into the case before they could arrest the person. They were still at a standoff where they were outside and the person was inside. And I had to be able to call the officer and then be able to discuss the law with him and be able to essentially resolve the issue without them forcing their way in to go and arrest my client. So you need to have the phone number of an immigration lawyer you know is competent, that is good, that you trust, even if you have not yet consulted them. So when you confront immigration officers, you say, I want to call my lawyer. And then you call that person and you tell the person what has happened, so they can step in right there and then. They may ask to speak to the officers, and depending on the scenario, they may talk to the officers and calm down the officers on your behalf, where you may end up not being arrested. Especially if it's me, I tell them, I'll bring my client to your office. You don't need to arrest them. I give you my word. I'll go look for them. I'll bring them. Stuff like that. Or say, what do they want? Discuss in a way without jeopardizing your client, of course, what they want. Bottom line here, body cameras can provide accountability for immigration officers, but they can also document the immigrant's conduct. So when dealing with immigration enforcement, stay calm, know your rights, and let your lawyer do the fighting. Don't go and be talking like an illiterate because you have a green card. Don't you know I have my green card? You cannot arrest me. You cannot. They will arrest you or say, oh, I'm an American citizen. You are speaking with a very thick accent. But you are telling immigration, I'm an American citizen. You don't have proof of that citizenship in your pocket. They will carry you and they will put you in detention. Your lawyer will get you out later if you're lucky. So you don't get belligerent. Even me as an immigration lawyer now, if immigration arrests me or they pull me over, I'm not going to start talking like an idiot. I say, do you know I'm a lawyer? I'm an immigration lawyer. I'm only going to get myself arrested. I will calmly explain myself. Sir, I'm an American citizen. Can I show you my citizenship record? Or if I don't have it with me, please, do you mind? I can call somebody in my house or you can follow me to my house. I assure you I'm a citizen. If you talk nice to them, they are not beasts. ICE officers, I'm telling you people, now I know that you guys like to get down on them. They are just doing their job. They don't make the policy. They work in an administration that has said, I want to get rid of as many illegal immigrants as possible. I want to get rid of criminal immigrants. Now they're even getting rid of just basically illegal immigrants. That is the administration's posture. They are getting memo from Donald Trump. If you guys don't know that, their guys are getting memo. When their guys get memo, they send memo to the boys on the field. Their job is to honor the law. Their job is to enforce it. Many of them don't even like arresting people like that. But it's their job. It's like those in the the F1 stuff that they set up. Their job is to go look at their record in the schools, look at their record on immigration. If they are F1 students and they've not been going to school or they're not carrying full load, they violated their status. And if their I-20 has been cancelled by the school, in fact, the officer I met gave me valuable advice. He said, immigration will not move against you as a student unless your I-20 has been cancelled by your school. I thought that was a very valuable piece of information. So you want to make sure, even if you are not attending school regularly or whatever, make sure that your DSO does not cancel your I-20 on the system. That's what activates them. And then, because once the I-20 is cancelled, I'm told, they are notified automatically. They're supposed to be notified within 30 days of the DSO cancelling your student visa, cancelling your I-20. Of course, some schools also understand. They try to help these immigrants. They don't submit it until day 28 or day 29, but they are going to submit it. Because otherwise, they also put their F1 ability in status. They're not going to do that for you. So they will submit it on day 28 or day 29. Immediately it's submitted to immigration that your I-20 has been cancelled. Now you are going to enter a database where there is a task force that is looking for you. That's their job, to come look for you wherever you are, bring you in to come and explain why you are not going to school. And from there, they put you in deportation proceedings. It's their job. They may not like it. If they don't want to do it, then they have to resign. So you can't resent ICE officers who are doing that. I'm not one of those lawyers who will start fighting with guys I know don't have influence on the law. They don't have influence on the policies they have to enforce. Worst case, if I think that there's something that should be done, I will ask to speak to their supervisor and then see if I can cajole, beg, or whatever. Me, I beg immigration for my staff. I don't do a boju, just in case you think that My own Rottweiler is very smart. I know when to bite, and I know when the time to become a puppy. Okay, you bite when there's nothing else to be done. Now the Rottweiler goes to war, and I will fight for you and never quit. But before we go to war, I still try to behave like a puppy first. Try to see if I can sweet up, because some of them have discretion. You don't go be fighting somebody who has a discretion. I expect him to exercise the discretion in favor of your client. That is stupidity. Rottweiler does not roll like that. Where there is discretion, I'm going to say, Bobo, I'm going to talk nice. I'm going to joke with them. I'm going to figure out if I can get them to exercise that discretion in favor, because your client don't care whether you shout or whether you jump up and down or whether you bite or you smile. All your clients care about is that he's not arrested or they get their status. So as an effective lawyer, I tell even other lawyers, you want to be nice to immigration officers in areas where they have discretion. Now, if they've exercised the discretion and it doesn't favor your client and you want to fight, then it's open season. The Rottweiler start biting anybody he can bite if it is legally going to help the client. So my point here is that we're talking about update number 7. I know I've diverted a bit. Immigration now, they are now going to be carrying cameras, body cameras, like regular police, to record their encounter with immigration, with immigrants. That could be a double-edged sword. It can help you in case you meet a nice officer who is nasty, and some of them are nasty. I'm not saying all of them are nice. Some have just been given the power to be racist because they are racist before. So they will deal with you anyhow. Some are doing their job professionally the way they're supposed to do it. Okay? He is being recorded. But you too, you are being recorded. Remember that. So if you are nasty to an officer of the law, they say put your hand behind your back. You are saying, why do I have to put my hand behind my back? You are arguing. All of that will also work against you in court. I hope we all get that. Update number 8. I told you there's a lot of updates today because we didn't have a show last week. The next update is talking about your I-485 form, which is the form you file to get your green card. It's called the I-485. Okay, they are going to be using a new form, because I have fallen for that before, where the system I was using did not automatically update the form, and I just used the form that was given to me by my immigration software, and I got the case sent back to me. They deny it on the spot, send it back, and we have to refile. So it is very important now for you to understand that to use the latest form that immigration has out there. They change them all the time. They already told us that on the 18th of September this year, that is in the next 20-something days, Form I-485 is going to be changed. Okay? So they're going to replace the current edition, which is the one that's 01-2025. They're going to replace it with another one. There's no grace period. Typically, when they change their form, they will give you grace period to still be able to use the old one for like 60 days or 180 days after the new one has taken effect. This one has no grace period. Beginning from September 18th, new I-485 will go into being. So if you are planning to file for your green card through adjustment of status, you need to pay attention to that. Okay? You need to file. But they don't, even though the forms are available now, they say don't use it before September 18th. In other words, if you go and use the new form for an application you are filing today, they are still going to deny it. You have to use the old form until September 18th. This is important because before, when they change form like that and there's a grace period, you can actually use that new form right now. But they're saying no. Immigration is very specific. If you are filing before September 18th, you must use the old form, even though if you have access to the new form, don't use it yet. Okay? Don't assume immigration will automatically accept whatever form I-485 that you file. Check the edition date. If you are filing before September 2018, make sure you are using the January 25 edition. If you are filing on or after September 18, use only the 9/18/26 edition. Do not file the new edition before September 18. I'm repeating, they will deny your application. And you should review, of course, all the instructions carefully. They've made changes to many of them. Don't assume. And I tell my staff never to assume. I don't assume. I'm going to read all the instructions again before we file. This is especially important, and the reason why I brought it here is because a lot of people file their own I-485 by themselves. They don't use lawyers, either because they don't have money or they don't want to spend money with lawyers. They go ahead and do it by themselves. It's why I'm including this. If you're going to do it by yourself, be smart. Don't use the wrong form and then ruin your own chance. Once they deny it, maybe your status expired thereafter, a lot of bad things begin to happen. The ninth and final update for today also has to do with using the forms that immigration give you. Now, immigration is telling us that they will reject all forms I-539 and I-765 beginning from September 15th. They've announced that they're going to publish new forms I-539 and form I-765, which is the one for your work permit, that they're going to publish a new one on September 15th. And it will replace the ones that we had before. One of them was August last year. The other one was August 2024. They have revised the forms to align with a new rule concerning admission and extension of state procedures for certain non-immigrant students like academic students, exchange visitors, representatives of foreign information media. They've changed the rules concerning them, and they have implemented it in this new one that is coming out. There is no grace period for these new editions, just like the one of I-485. So if you are filing I-539, which is a form you file to extend your non-immigration status, let's say you want to extend from B1 to O1 or whatever, it is from I-539 that you use to change your status or to extend your status. Let's say you came in with a B1 and you want to extend that status. It's I-539 you file. Let's say you want to change from one status to the other, as long as it's non-immigrant, it's from I-539 you're going to use. And of course, from I-765 is what you're going to be using to apply for employment authorization. They're saying now, using the wrong edition after the deadline will lead to rejecting your application. So you need to be smart. Before September 15th, that is over the next 20 days, use the old forms. For the form I-539 to extend or change your status, use the edition of August 28, 2024. August 28, 2024. That is the edition you are using now. To file for work permit, you have to use the edition of August 21, 2025. But on or after, because the thing starts on September 15th. On September 15th and after that, don't use those old forms. Immigration will reject it. And your money is gone. They're not going to refund your money. They will take it because you remember, you are paying the money online now. You are not getting it back. Unlike before that, they will send everything back with your check. Oh, yeah, the money is gone here, Otilo. Okay? You have to use the new September 15 edition now. Okay? And don't use the September 15 edition before September 15. All these things matter now. Immigration is getting more technical every day. It's why I always advise, please use a lawyer. If you don't want to use a lawyer, make sure you go to their website, USCIS.gov, and read the instructions thoroughly on the form and on the website. This is important. I wanted to share that with the world because most of those who are in America who are not yet green card holders, they have work permits. They file I-765. That's a very important document. That's the document people file to get their work permit. So you need to know that rule now. You need to use the old forms until September 14th. From September 15th and up, you want to use the new form. That is what all the updates for today. But of course, your own individual situation may require for you to talk to a lawyer or just to even ascertain where you are. I want to encourage you to book your consultation at banwolaw.net/consultation. We do consultation online on Zoom if you want, or if you want to come to our physical office in Dallas, Texas, which is Arlington, You can also book it there. So when you go to the website to book, it will ask you, do you want to do in-person consultation or do you want to do a Zoom consultation? We represent people nationwide or globally. Please go book your call and let's talk. It's only $100. I can tell you that in advance for a 1 hour one-on-one discussion where you can ask me all the questions. I can analyze your case for you and all that. It's about the best $100 you will ever spend in your life. If you don't want to book it with me, find a lawyer online that is credible. Book your consultation. Some charge 200, some even do some 15-minute free consultation. I don't imagine how much you're going to get from that. But if you really don't have any money, book that. It's better than nothing. And at least talk to the lawyers. You can book your call there, banwolaw.net/consultation. When we come back, now we're going to take your question and answer for the week. And I promise you, I'm going to try to take as much of your questions as I can take within the time that we have. But before we come to that, we're going to have a short break where I'm going to play some videos where I've pre-answered some questions in advance. Hopefully, the question you're about to ask me is one that has already been answered in one of these videos that I'm about to show. I'll be back in a couple of minutes. Many green card holders believe that once they receive permanent residency, they are completely safe. But that belief can be dangerous. A green card gives strong immigration status, but it is not absolute protection. Certain criminal convictions can still trigger deportation. Fraud findings can put permanent residency at risk. And even long trips outside the United States can sometimes raise immigration questions. I've seen permanent residents shocked to learn that their green card did not protect them the way they expected. That is why legal advice matters before making important decisions that could affect your status. If you're a green card holder and have questions about your immigration situation, visit banwolaw.net or call 888-215-5054 today so that we can review your case. If immigration officers ever stop you in public, the next few seconds matter more than most people realize. Many immigrants panic and start explaining everything. But talking too much can actually hurt your case. So remember these three important things. First, you have the right to remain silent. Second, you can ask to speak with a lawyer before answering questions. And third, never give false information. Stay calm, do not argue, and do not volunteer information that was not asked of you. Those few decisions can make a huge difference later if your case ever appears in immigration court. If immigration officers have approached you or someone in your family, visit banwolaw.net or call 888-215-5054 today so that we can help you understand the safest next steps to take. Never ever sign immigration paperwork unless you clearly understand what it means. Sometimes immigration officers present documents and ask people to sign quickly. But signing the wrong document can waive important legal rights. In some cases, it may mean agreeing to voluntary departure. In others, it may mean admitting allegations that could later be used against you in immigration court. Once a document is signed, reversing that decision can become very difficult. That is why it is important to slow down, read carefully, and understand what you are signing. Better still, tell them you are not signing without a lawyer. Your signature carries legal consequences. If anyone asks you to sign immigration paperwork and you are unsure of what it means, please visit banwolaw.net or call 888-215-5054 to speak to a lawyer before signing anything. Protecting your rights begin with understanding your documents. My name is Ope Banwo, and they call me the Immigration Rottweiler. Not because I bark, not because I make noise, but because I don't let go. When your case gets tough, when the system pushes back, when others start telling you there's nothing we can do, that's when you call me. Because once I lock into your case, I don't stop, I don't quit, and I don't back down until we get results. So go book a consultation on speakwithope.com now, and let's activate the Rottweiler mode on your case before the immigration knocks on your door. Yeah, we don't pray that immigration knocks on anybody's door, but it is happening a lot now. And you, as an immigrant, you need to pay very, very close attention to make sure that you don't lose guard, as they say in my country. This is not the time for you to lose guard. Because if you lose guard, you can find yourself back in Kenya or find yourself back in South Africa. You have to stay alert, know what's going on, and make sure an immigration lawyer is not far from you. All right, we get to that point where we want to talk about questions, Q&A from the audience. So if you have any questions for us that you would like for me to answer, please go ahead and post it wherever you are watching this right now. Sometimes when you post on the thread that you are in, we get the answers. I will get the question pop into the studio, and we can put it out there. Let me bring up my partners in crime on this one. They are the ones helping me to collate the questions from the why is okay okay, I'm trying to get them on stage here. I have my assistants here tonight. In fact, we have 3 of them on the show tonight, but Okwayemi is down there watching everybody. But we have a Grace and Samuel. All of you are familiar with that. We are onboarding one of my new paralegals into the show. Maybe tonight, let's even introduce Okwayemi Aguda, one of our he's actually our office manager for the Arlington office. Okwayemi, welcome to the show. It's your first time showing up here.
Thank you, sir.
I joined the show tonight.
Yes, sir.
All right. Thank you so much for being with us, and hopefully you guys are going to be seeing more of my pretty assistant as we move forward. All right, Samuel and Grace, are we ready for the Q&A session today? All right, what have we got? Let's go. Samuel, maybe you want to go first with your own curated question. Let's start with that. All right.
All right, sir. Good evening. Yeah, well done, everybody. We have here a question from David from Arlington, Texas. He's asking, I am an F1 PhD student with a pending EB2 NIW I-140. Will that affect my I-539 extension request after the new F1 rule ends duration of status? That's from David in Arlington, Texas.
Okay, let me understand. It's saying that it's an F1. Put up the question. Let's see it so that people at home can also see what the question is. If you have it,
all right, sir.
Yeah. Okay. Yes, thank you. So I'm an F1 student with a pending EB2 NIW I-140. Okay. Will that affect my I-539 extension after the new F1 rule ends duration of status? Okay, this is like a compounded question for those who may not be aware. Immigration has a new rule that they are proposing where if you come in as a student with F1 now, they won't be giving you DS anymore. DS is duration of status. As long as you are still a student, you are in status. But they want to change it where they are going to give you specific time that you can stay here as a student. In other words, they will give you expiration date like everybody else gets for their I-94, because a lot of students come in, they are not even going to school or they are not carrying full load, but because they are DS, duration of status, they can stay here for many years. Immigration wants to change that. So this question is asking whether is pending EB2, which is an employment-based immigration category, worker category, which will fall under I-140. Just don't worry about the plenty technical stuff. EB2 is for outstanding professionals who want to get green card based on their expertise. So it's asking if, as an F1 student with a pending EB2 petition, whether this will be affected, whether this will affect his extension request. Well, David, if the new immigration rule requiring certain immigration F1 students, okay, if it's requiring certain F1 student extensions that you file through I-539, okay, it's going to apply to your case. Okay. Immigration will generally review whether you are continuing to meet the requirement of your F1 status, including whether you have been carrying full-time enrollment, your academic progress, your financial support, and a legitimate need for additional study. So you can't just, coming to study, I have something in my eye, my apologies. So the fact that you are moving to a PhD level now does not mean they're going to waive the rules for you. They will still review whether you continue to meet the requirements of your F1 status. Have you been going to school? Have you been carrying full load? Have you been operating as a full-time enrollment, or you are just a guy who takes one course at a time just to keep your status? How is your academic progress going? Do you still have the financial support to back up your F1? And do you have a legitimate need for additional study time? They're going to ask all of that. Meanwhile, your pending I-140, which is the petition for alien worker, does not automatically prevent approval of your extension of your F1. You have to understand it does not automatically, because the EB2 that you're applying for is a dual intent visa. However, because the F1 status is generally based on non-immigrant intent, a pending employment-based immigration petition may just be one factor immigration considers when evaluating your application, your university support letter, your updated academic plan, and the evidence that the extension is academically necessary can strengthen your request. So given the potential impact of the current regulatory changes and your pending I-140, you have to work closely with your designated school official and an experienced immigration attorney before filing this. Because one of them, the EB2, is an immigrant intent application. Your F1 extension is a non-immigrant intent application. While they didn't say automatically the fact that you are filing EB2 because one of the dual intent types of visas, while that will not automatically cancel your non-immigrant intent, they're going to look at all of that and they may choose to deny you if they feel that one of the factors is not being met. So this is not something you file casually by yourself. I'll personally advise you, Mr. David, you are straying into, I know you're a PhD student, but you are straying into very, very esoteric area of immigration law, the intersection between an immigrant visa and a non-immigrant visa that you are trying to extend is something that you have to prepare for seriously so that you don't get into trouble. I hope that answers your questions in full. I try to do my best to give a full explanation to the question that you ask. All right, Samuel, can you pose the second question that you got?
All right, I have another question here from Michael in National New Hampshire, USA. He says, and is asking, I missed the departure flight I submitted with my I-539 RFE, but my I-539 and H-1B change of status are still pending. Could this hurt my case? That's from Michael.
Okay, I don't like using a lot of technical terms that will confuse, especially those who might not be conversant with this. So what you are saying, Michael, is that you missed the departure flight, which is part of, you have to tell them when you are trying to extend your stay. Obviously, that if you file an I-539, that's probably what you're trying to do. When you're trying to extend your stay, you have to tell them when you are planning to leave. Remember, extension of your non-immigrant status is that you are not staying here permanently. You just want them to give you more time for you to be here. Part of what we have to submit is proof that you plan to leave, which is your ticket to leave as at the time your departure ticket. Okay. What you are saying now is that you missed that flight. In other words, you didn't take it. Very good. And then you also have the H-1B thing still pending. So I'm assuming that this is your H-1B change of status is what you're talking about, not B1. Well, if you miss your flight, could this hurt my case? Well, I have to be honest with you, Michael. It could. Because immigration generally considers the evidence that you submitted in response to the request for evidence. Apparently, when you file, they sent you an RFE. They sent you a request for evidence that they want more information. And then you submitted the information and then you didn't go. So they will consider all the evidence that you submitted and they may decide or they will evaluate whether your actions remain consistent with the evidence while your case was pending. If you told immigration you intended to depart on a specific date, but later remain in the US, then immigration may consider that when they are assessing your credibility and whether you complied with the terms of your requested B2. Okay, so you had a B2 that you are trying to extend, and then you also then have your H-1B pending. I see. Oh, they will consider that if you told them when you are requesting for your EB2, your B2 extension, that you are going to leave on the 21st of January or whatever time you pick, that time came, you missed your flight. It may very well affect your H-1B status that is pending. Because the fact that your new employer filed an H-1B change of status for you before you requested your B2 period, before your requested B2 period expired, is an important factor. Now they file an H-1B for you before you are requesting a time extension of your B2, but that time expired before your employer, or rather, before that time expired, your employer filed an H-1B change of status for you. That is an important factor. It looks like you are visa shopping, and it may help preserve your eligibility if you filed it before your B2 expired. But it does not automatically resolve the issues that were raised in your I-539. See, because once your status expired, obviously they won't let you change to H-1B or any other status. But the fact that your employer filed file the H-1B application for you before your temporary visitor status expired, that may preserve your eligibility to get your H-1B. But it does not automatically resolve the issues that were raised in your extension of your B2 that you filed before. And because both applications remain pending, I would advise you to stay in close contact with your lawyer if you file with a lawyer. If you didn't, then you need to stay in constant touch with developments in immigration. Or better still, I will advise you go talk to a lawyer right now. Because if necessary, your lawyer may be able to explain why you did not depart, and he will address any concerns before immigration makes a decision. Because they have the information with them now. You have given your word that you are going to leave. You have submitted document that you are going to leave, and you didn't leave. That needed to be explained, or it will affect both applications. Right? That's the best I can tell you now. Most importantly, go talk to a lawyer to be able to explain why you missed that flight, what happened with that. Because for immigration, they might think that you are playing games, that you deliberately did not go because now your employer has put in an H-1B and you are trying to wait for that H-1B to be approved. When you yourself have told them in an RFE that I'm going to leave on September 4th or whatever, and then you miss the flight and you think it won't count. It definitely will, because now all the files play together, the system plays together. So I would suggest you get in touch with a lawyer. They might decide whether they want to put a supplement in there to explain why you missed, or the lawyer may advise you to wait until you see what they decide. I don't know, because I don't know the full circumstance of your case. Every case is different. So I would suggest you meet with a lawyer to look at this. Don't just ignore it and think that it will go just because you have prayed about it. It may not go. All right, let's get something else. Let's get the next question. Mr. Samuel, do you have anything else before I go to what Grace has been able to gather for me?
All right, yes, I have a question here from Jennifer in Seattle, Washington, USA. He is asking that USCIS asked me to file an I-601 waiver after my green card interview for possible misrepresentation. Are these waivers still being approved? That's a question from Jennifer.
Okay, let's pull it up. Okay, thank you. So, immigration asked me to file a 601 waiver after my green card interview for possible misrepresentation. If they've used that word, problem is already coming. Are these waivers still being approved? Well, Jennifer, yes. Form I-601, that's the application for waiver of grounds of inadmissibility, which obviously misrepresentation covers. That form is for those who have become ineligible or inadmissible because they have done something like misrepresentation, fraud, or whatever. Okay, but your question is whether those waivers are still being approved. Yeah, they are still being approved when applicants meet the legal requirements, regardless of what they are telling you on WhatsApp or on rumor mills. There is no USCIS policy stating that all I-501 waivers must be denied. There's nothing like that. I still checked, at least as of yesterday. I don't know about today. Okay? There is no policy saying that they must deny all waivers based on 601. Approval depends on each specific fact of the case. So if your waiver is based on alleged misrepresentation from what you are saying, you must generally show that denying your admission or denying giving you a green card will cause extreme hardship to a qualifying U.S. citizen, not just any U.S. citizen, a qualifying one like a son, a child, a wife, a father, or lawful permanent resident, spouse or parents. Okay, those ones are limited to spouse or parent, along with meeting other legal requirements. So immigration then reviews each waiver individually. They will consider all the evidence that you have submitted. So strong documentation and a well-prepared legal argument can significantly affect the outcome. I always tell my clients or anybody who comes into contact with me, you want to apply for a waiver, you need to get a lawyer. It's not even supposed to be optional for you because, yeah, you can try it. Some have tried it and have won. I'm not going to tell you it's impossible. I'm not that kind of lawyer who's going to tell you, oh, you must use a lawyer. But if you don't use a lawyer, I think you'll be foolish when it comes to 601 waivers, because not only must you explain what that denying you will cause extreme hardship to a qualifying U.S. citizen or lawful permanent resident. The word extreme hardship is a technical term that you have to meet. It's not just you have to document it. Okay. In addition to that, for you to really win, there should be a well-prepared legal argument that supports whatever documentation you are supporting. If you are not a lawyer, you cannot make a well-prepared legal argument. You can try. So if USCIS or immigration requested that you file an I-601 after your adjustment interview, no, they already have a problem in mind. You have to respond carefully and on time. They are not going to tell you to go file a waiver if they don't have a problem with your application already. So you have to respond carefully and on time. I would most recommend you work with an experienced immigration attorney to prepare a thorough waiver package. Gone are the days you can just submit the I-601 form with one or two documents and then you think they're going to approve it. No, it has to be a thorough waiver package that is addressing the specific inadmissibility issue. In your case, misrepresentation. You have to submit documentation as well as a legal argument as to why that your own particular misrepresentation should not bar you from being able to be given a green card. So it's not pepper soup stuff that you just go and sit down and be using some ChatGPT to write without following a due process. Go get a lawyer who can review this thing for you thoroughly, know what they are looking for, and then hopefully you win. So Jennifer, they are still being approved, but they're only approving the ones that are properly documented, that are solidly, because waiver themselves before used to be easy. But these days, they are denying a lot of them. I agree with you, they're denying a lot, but there's no blanket denial of 601 waiver. They are still applying, just like asylum. Some people are still winning asylum cases from countries that you are not going to be. Some people are still winning asylum cases from Mexico if they really have a genuine case. They have not banned anybody from filing any, some of this stuff. It just has to be genuine and it has to be properly documented. And that is what I will advise you. Okay. All right, let's get the next question. Let's look at some of these live people. The one I see some live questions here. Let me see if we can find. I know I saw several before that as posted here. Let's pull it up. I think that is what is it called now? That is I'm trying to put it up there. Can you guys see it? Because I'm not seeing it.
Yes, you can see it.
Yes, sir.
Just a second here. Okay. Yeah, Yeboah Quadwo. That is it safe to apply for N400 if I stayed outside USA from 2019 to 2022? I came back in 2022 and I'm still here. I qualified for both rules. I don't know what you mean, but I qualify for both rules. So if you're outside the country continuously from 2019 to 2022, the fact that you now meet the physical presence requirements does not automatically mean it is safe to file from N400. A trip of 1 year or more can break your continuous residence for naturalization purposes. Remember, as an immigration, as a green card holder, you are not even supposed to be outside the country for more than 180 days without getting permission in advance. So since you have been out of the country for 3 years, that can actually break your continuous residence, meaning that they will tell you have to start afresh, meaning that the ones that you had before may not work. So whether that old absence affects you today depends on the exact dates that you left and you returned. Your green card dates, whether you are applying under the 5-year or 3-year rule, because some people can apply after 3 years if you are married to a US citizen. Some is 5 years if, for instance, you got your green card through asylum or through other stuff. So it depends on the rule that you are following and your complete travel history. They're going to make you put your complete travel history during the statutory period. So if you are covered, if your own is 5 years before application, then you are going to have to demonstrate that you have 5 years continuous residence here, 5 years before you apply. If it is based on the one for 3 years, like married to US citizen and co, you have to show that you have 3 years continuous residence here. So since you have been back, like according to you, since 2022, the 2019 to 2022 may no longer fall within your statutory period, especially if it's a 3-year stay that you need. If you came back in 2022, we're in 2026. So if you have stayed and not gone anywhere, then that break may not affect your ability to file for citizenship, because you'll be able to have that 3 years. But don't just rely on the US online eligibility calculator. Sometimes those things don't work in practice the way you think. You must have an immigration lawyer review your green card history and review so you have to actually write it out. It's a mathematical thing, okay? Before you submit your N400, be sure that you have the requirements. If your green card is based on asylum or any other status that require you to have 5 years before you file, you may not be eligible right now because the continuous residence may have been broken because you were outside the country for more than a year and you have to start over. If you started over in 2024, we are not 2022, depending on the month, you may not have accrued the 5 years required. So if you are unsure, you need to schedule a consultation to have your naturalization eligibility reviewed before filing. It's important. Yeah. When I keep saying get a lawyer, get somebody to help you review it, it's not just because I'm trying to get work for lawyers, whether the one in your neighborhood is the one you use or whether you use me. is because I know these things matter. You don't want to spend all that money or then wait all that time. They call you for your interview and then they deny it right there that you're not eligible. You'll have wasted money, you'll have wasted time, you'll have wasted all sorts of stuff. So it's better to find out about your eligibility before you actually put in the application. Do not assume, even if you're a 3-month, a 3-year a green card to citizenship filer, still talk to an immigration. You don't even have to use them to file the N400 if your problem is that you don't want to spend money. But at least do the consultation so that they can help you with the calculation and let you know whether you qualify or not before you go out there and start spending some serious money. That would be my advice for you. And I appreciate you being on the show and putting your stuff directly on the screen for me to see what your question is. All right. Thank you so much, Mr. I hope that answers your question thoroughly. Mr. Samuel, what else have we got?
Yeah, we have another question here from Kelvin in Avodele Estates, Georgia, United States. He's asking, can I keep my full-time H-1B job and use my marriage-based green card EAD for a separate part-time job? That's from Kelvin in Georgia, United States.
That's interesting because the green card, can I keep my full-time H-1B job and use my marriage-based green card EAD for a separate part-time job? I thought that was interesting because when you get a work permit through marriage, it allows you to work everywhere. You don't even have to continue to be in H-1B. You can actually use that to actually get out of the H-1B designation and work like somebody who is authorized to work here. But obviously, maybe you have some concerns about whether they're going to approve your marriage-based petition. So my question will be, yeah, you can actually use your employment authorization that you got through your USC spouse to look for a part-time job, because somebody who with a valid H-1B and a valid work permit based on pending marriage, okay, may in some cases continue working for the H-1B employer while also accepting a part-time job using the work permit he got through marriage. However, you need to understand this, and it's important. Hopefully, you are paying attention here. You have to understand that using the EAD, that is the work permit for additional employment, can have implications for maintaining your H-1B status. So if you want to preserve your H-1B as a backup, because I'm suspecting that's what they're thinking, as a backup in case your green card application is delayed or denied, you should continue complying with all H-1B requirements, including working under the terms of the approved H-1B petition, despite the fact that your new work permit through your spouse can actually allow you to switch that with your employer so that you are now no longer at H-1B position, you are just now working as a regular person. But if you want to preserve it, then you should understand that you must keep working under the terms of the approved H-1B, at least with your employer, because this is a technical area of immigration law. You need to consult an experienced immigration attorney. Again, I'm saying it over and over because I've seen people ruin their own cases because they assume they know when they don't know. This particular area is very technical. You are in H-1B. You want to preserve that H-1B, but you want to use the work permit that you got through marriage to U.S. citizen to get part-time work. The answer is yes, you can do that. But for you to successfully be able to keep that your backup, that your H-1B as your backup, in case they deny your application with your spouse, you need to maintain the terms of that H-1B. So that your part-time work that you're going to get, if care is not taken, can actually take you out of the terms of the H-1B. So that if you do lose your case with your wife, you may not be able to go back to H-1B because you have violated it based on the work you went to do with the other work permit. That's why I'm telling you that it's a technical area. You need to consult an experienced immigration lawyer before you start that second job to ensure that you do not unintentionally affect your H-1B status or forfeit your future immigration benefits. There's a very, very, very big chance of you doing that. So you don't just say, oh, I'm married now, I can go and do a part-time job with that while I'm also keeping my H-1B. Whatever job you do without your part-time work through your marriage to your spouse can actually affect your H-1B status, so that if you then need to continue in that status, then you may find out that you have already violated it. So it's not a casual area that you can just do and file form and say, I fill form rather, and say you're okay. I hope you get that. Let's take a one more.
Yeah,
What do we have?
yeah. This question here is question number 5 from Mariam in Quincy, Massachusetts, United States. She's asking, I am a green card holder and filed my taxes as single, but I am married to someone living abroad. Do I need to amend my tax returns before applying for US citizenship? That was a question.
That's an interesting question right there. But before I give you an answer, I want to first issue a disclaimer. I'm not a tax consultant. Okay, even the legal issue I'm giving here is just for information purposes. Don't rely on it until you have spoken to your lawyer. And that is even more effective and more important when it has to do with tax laws. I'm not a tax lawyer, so don't take anything I give you as legal advice. Talk to a lawyer, a tax lawyer, before you do anything that has to do with tax, so that you don't get into IRS problem. Same way too, whatever legal advice I give here is for information purposes only. At least if it has to do with immigration, I have some expertise there. But even that, I don't want you to take it as something you're going to act on, because every case is different. Before you act on anything I've said, make sure you talk to a lawyer, make sure you double check to be sure that it applies specifically to your case. So, but let's come back to this question. Okay, you're a green card holder who is filing your taxes as single, but you are married to somebody who's living abroad. I'm assuming that person living abroad is not an American citizen, otherwise this will not be a question. So do I need to amend my tax returns before applying for US citizenship? Maria, I'll be frank with you, maybe you need to. Because for naturalization, immigration may review whether you have complied with your tax obligations as part of evaluating your good moral character. I have seen people have come to my office to help them see if I can help them appeal their citizenship decision because immigration denied it on the ground that they did not file their taxes on time. They are saying now that if you don't file your taxes, you don't have good moral character. Remember, good moral character can be, there's laws. So you have to file taxes. So if you're avoiding taxes, then you don't have good moral character. So when people want to file, we typically will advise them to go update all the taxes that they've not filed before. At least if you file it before you meet them, they might say you are late. At least most Americans are late in their taxes. You can still get away with that. But to go to immigration without filing taxes, you're going to get denied on a good character. So when you are filing your citizenship, okay, they may review all of this. And if they found out that you are married but you are filing single, then you have not filed the proper taxes. Because you can't be married even if your spouse is living in Miami or living in Togo and then be filing single. You are not single, you're married. Okay? So a spouse living abroad without a social security number or having an immigration status does not automatically mean you should file as single. I can't count how many people I've had to explain that to. You are not single. In many cases, married people, whether they are living with their wife or husband or not, whether their husband or wife is here or not, you can only file as married filing separate or married filing jointly. In fact, my understanding, again, I preface it by saying I'm not a tax specialist. Don't take my word for it. But if you are married, you can't even file head of household. If you are married, it's either married filing separately or married filing jointly. But a lot of people do it, and then when they get into problem later, they'll be wondering what happened. So I'm going to strongly encourage you, talk to a tax lawyer. I may also be talking rubbish. I'm not a tax lawyer. I'm just telling you the little I know. So if your prior tax returns were incorrect, it may be advisable to file an amended returns before your naturalization interview. See, because remember, the big part that trips people up on their naturalization is not whether they have been here for 5 years or 3 years. It's always lack of good moral character. And many people assume that if they have not committed a crime, they've not been jailed for anything, they have good moral character. That is not so. Filing the wrong taxes can be interpreted, especially now in this current immigration climate, like you don't have good moral character. But if you make attempt to fix it, because if you file the wrong taxes, you can file amended tax returns at any time. IRS will allow you to do that. If you are now owing them money, they might tell you to pay some penalty or interest on it, but at least they will allow you to amend it. Even if you filed wrongly, and immigration sees that you have filed to amend it before the interview, doing so can demonstrate good faith compliance with US tax laws, and your lawyer can argue that later if they want to deny you based on that they are not the one that told you to go and fix it. You are trying to fix it before you came, meaning that you have good character. You just made a mistake. Anybody can make a mistake, and you are trying to fix it. So before filing your N400, I'm going to encourage you strongly. Consult both a qualified professional that handles taxes. In other words, a qualified tax professional, and then an immigration attorney to determine whether amendments are necessary and how they may affect your citizenship application. From where I'm standing, without knowing much of your personal history, I will tell you right now, it will affect your naturalization thing because it is wrong filing. You might meet somebody that is an anal person when it comes to dotting the I's and the T's. You are married, but you file single. They could say you file single because you want to avoid paying the proper taxes. They could say that you deliberately claim you are single because you want to deceive immigration. They're not going to be hearing from you that my husband or my wife is in Togo. If your husband is in Togo, does that not mean you are single? You are not single. You are not living alone, or you are separated. So your taxes cannot be single. But that's me. Don't take my tax advice as legit. Go talk to a tax consultant and then talk to an immigration lawyer before your N400 interview so that they don't deny it based on something you can fix before that time. Okay? All right, let's take next one. Mr. Samuel, thank you so much for helping me out in getting the questions for me from everywhere. Thank you so much.
All right, sir. We have another question here. That question number 6 from David in Orlando, Florida, United States. He is asking that my N400 has been pending for over 24 months, and my I-751 is also still pending. What can I do to move my case forward?
Okay. My M400 is pending. Put up the question. Let's put it up so that those who are watching can also see it and everybody can learn from that. Pull it up. That will be your question 6, right? Okay. My M400 has been pending for 24 months, and my I-751 is also still pending. Now, like I said, for many may not know what all this 757 means. 751 is petition to remove conditions of residence. Okay. Sometimes when you go to immigration, if your marriage is not yet 2 years before the interview, okay, what they will do is they will give you what is called a temporary green card for 2 years, and then you are supposed to file this form they call 751, which is to remove conditions of residence. That's the form you file, petition to remove conditions of residence. Okay, and then now, so this question is he has an N400 pending for over 2 years, and the petition to remove conditions of residence is also still pending. Now, of course, it is common for immigration to determine both of them together. They have it. They can, the time they make a decision on the 751 and N400, they can adjudicate both of them together. So, but a delay of more than 2 years may justify further action on your part because that is not supposed to be normal. So you may want to consider submitting what they call normal processing time inquiry if your case qualifies, there are requirements for that. And in your case, I think it does qualify. If it has been pending for more than 2 years, you can make a processing time inquiry, especially if on their website they had said that the processing inquiry is less than processing time is less than 2 years, but your own has not taken more than 2 years. You can actually do that, or you can request assistance from your U.S. senator or representative who can make what they call congressional inquiry with the USCIS. Now, this is powerful if you know how to do it right, because I've used this very recently for several of my clients, and it has worked like magic, where you actually write to their congressman. There's a way you do the petition. There's a way you request them, their documentation to submit, and they will get into it for you. Most of them have dedicated officers to help you get your rights before government agencies. So they're not really doing you a favor, it's their job. But you have to approach them well, and you have to submit the right documentation. They will face off with immigration on your behalf. Okay, there's also something they call immigration ombudsman now. A lot of people are not aware of that. You can also petition the immigration ombudsman to help you intervene in the matter. They also have requirements for you to qualify, but this is an office that have been set up by law to be between the immigrant and immigration. It's called the Immigration Ombudsman. They are very effective. I've used them maybe 4 times in the last 1 month alone. And as the result it has been amazing. They will take it up, they will contact the officer there, they will follow up for you. And immigration typically don't like to see them involved. When your congressman and your ombudsman is triangulating them and asking about you, typically they will make things happen in your case. So you can also do that. You can also consult. If you can do those yourself, the Office of the Immigration Ombudsman. If you type that in your Google, you will get their website. You can go there, read their instruction, and follow it. Requesting your congressman. That also, if you go to the website of your congressman or your U.S. senator, they always have a button there about inquiry with immigration. Most of them, you can click on it, read their requirements for them to help you, and you can follow through. Or you can also consult an immigration attorney to determine whether you will now want to file what is called a writ of mandamus, whether it's appropriate. Because if they delay your case too long, you can take immigration to federal court on what is called writ of mandamus. And from experience, immigration doesn't like that mandamus thing, because your action is now saying the federal court should require immigration to make a decision on your case. Remember, the mandamus doesn't guarantee you are going to get the result you want. That's not what the mandamus is. The mandamus is for the court to give them order to make a decision one way or the other on your case. And from my 29 years experience, many years even till this time, most times when you file that mandamus and you serve immigration, they don't want to go to federal court. They will make a decision. Now, of course, if you don't qualify, they're going to deny you, but they don't penalize you. Immigration is not like African courts where they would then say, because you took them to court, they're going to deal with you. They don't think like that. I can tell you from experience, they're not going to victimize you because you went to federal court. They're not going to pull the file. The supervisor will pull the file. They will find out why is the case being delayed, and they will make a decision immediately. So before your case is even heard, 70% of the time, immigration will decide your case once you serve them that mandamus. Now, if they have a legitimate reason why your case is being held, that's a different matter. Then they will join issues in federal court. They will then come and explain to the federal court the reason why your case is being delayed. So those are your options. And I encourage you, if you have a good lawyer, they will pursue all those 4 grounds simultaneously. That's what we do. If your case has been delayed more than necessary and you want us to do inquiry, we'll do inquiry with immigration formally in writing. We'll get your congressman involved. We'll contact them and write the petition to them. We'll get the ombudsman involved to activate on your behalf, and then we'll ask you if you are ready to go to federal court. We might hold the federal court one back because that one will cost you extra money, for instance. Maybe just doing those 3 will get your case moving. But for those who really need decision done now, they can your lawyer can also file mandamus joint. So you have 4 things that is chasing immigration now. And I'm telling you, unless there's some extraordinary reason why they want to pepper you. They're going to either call you for a new interview or they're going to grant your stuff. Everyone that I've filed, has been my experience. Some of them, they will schedule them for a new interview immediately. Some of them, the card comes out, whether it's a work permit. And I've done plenty of this. The work permit will just come to you in the mail. They don't want those type of trouble. Unless there's a reason, then they might call you. So that would be my advice for you. What you can do to move your case forward to come back to this, David, is very clear. Go get a lawyer and ask your lawyer about doing 4 things for you. That can they do immigration inquiry on your behalf. The way you do it is different from the way a lawyer would do it. You can go to immigration website right now and make your inquiry, and that's fine. Some people get resolved with that. You don't have to pay a lawyer for that. Ask your lawyer whether they can do ombudsman intervention. Again, you don't have to use a lawyer for that. You can go to the ombudsman website and they have very clear rules about what to do, how to do it. So you can decide you want to do that. Number 3, you can get your congressman involved. It's called congressional inquiry. All those 3 you can do by yourself if you really want to do it. It is a mandamus one that you can't generally do by yourself because a lawyer has to file, even though you can go land and file. America is funny. You can file your case by yourself. Nobody will stop you. But you'll be stupid to do that. You get a lawyer. They know the law. They know all the stuff that need to go in there to file for you. But my recommendation will be get a lawyer to do all 4 for you so that you're not doing it yourself. So since they're doing it as one action, your fees are not going to be too much. They're not going to charge you separately for each. At least I don't do that. I charge you bulk and I do all 4 for you. All right. So I think that is where, for now, let's take a break before we break for the day. We've gone way over the 2 hours that this show is supposed to be. It's now 2 hours, 6 minutes. But before we go, let me take a short break, and then I will play a few videos that we have pre-prepared in advance that will help you. Hopefully, it might be the question that you have been waiting for in there. And before we do that, of course, I also want to remind you again that we have a newsletter now that can actually, it's like subscribing to a lawyer without paying me any money, that gives you information on a monthly basis, what has happened in immigration for the month. In there, I have some training on immigration. In there, I have some advice for you. It's a very robust magazine or newsletter that we're just launching from the stable of the Banwo Law. Here it is, and then I'll be right back after this.
Stop! Before you file another immigration application, before you renew your work permits, before you attend your next deportation hearing, before you travel to the USA, before you listen to another immigration expert on social media, you need intelligence, not guesswork. Every single week, American immigration laws change. New policies are announced. Court decisions shake things up, and one wrong move could cost you your visa, your green card, or even your American dream. I'm Attorney Ope Banwo, better known as the Immigration Rottweiler. For almost 30 years, I've been fighting for immigrants across America. Now I'm putting that experience to work for you free. Introducing the Banwo Immigration Newsletter, your monthly immigration intelligence report. Every month you'll receive the biggest immigration stories you must know, a powerful masterclass that breaks down one complex immigration issue into plain English. My famous Rottweiler's immigration tip to help you avoid expensive and heartbreaking mistakes. No legal jargon, no politics, no fear. Just practical immigration intelligence from someone who's been in the trenches for nearly 3 decades. And the best part? It won't cost you a penny. So don't let ignorance become your biggest immigration problem. Subscribe today at banwolaw.net/newsletter. Stay informed, stay protected, stay one step ahead.
One simple mistake that destroys many immigration cases is something most immigrants don't even think about: not updating your address with immigration. When you move to a new address in the US, immigration law requires that immigrants must update their address with the USCIS, not just the post office. But many people forget to do this. And here's the danger. USCIS sends important notices only by mail, interview notices, requests for evidence, biometrics appointments. If those notices are sent to the wrong address and you never receive them, immigration may assume you ignored the notice, and that can lead to case denials or serious delays. At Banwo Law, we represent clients nationwide, and we help immigrants track important immigration requirements so that small administrative mistakes like that don't create big legal problems or become nightmares for them. If your immigration case is pending and you have recently moved, please make sure your address is properly updated. Meanwhile, if you are out there and want to protect your American dream or avoid the American immigration nightmares, book an appointment today right now at banwolaw.net or call 888-215-5054 to book one. We represent clients nationwide. Are you in deportation proceedings? You need to hear this. If you have received a notice to appear or missed an immigration court hearing or fear that ICE is coming for you, what to do next is critical. Many people lose their cases not because they had no options, but because they acted too late or followed bad advice on social media. I'm Ope Banwo, an immigration attorney with over 29 years of experience in immigration law, with over 12,000 cases handled in the process. One thing I have learned in all those years of helping so many people successfully fight their deportation case nationwide across many states is that deportation isn't always automatic just because ICE charge you to court or want you out of here. Depending on your situation, you may actually qualify for asylum, cancellation of removal, adjustment of status, convention against torture, or some other forms of relief that you have probably never heard of. Also, I know for a fact that immigration court punishes delay in putting your defenses together quickly with an experienced professional. So please click the link below to book a deportation survival strategy consultation session with me today. On this exclusive one-on-one call that we can do either on Zoom or in person at our offices, I will evaluate your case honestly, identify your defenses for you, and help you map out your exact next legal steps to give yourself the best chance to win. Fellow immigrant, doing nothing is not a strategy. Waiting can cost you your case and turn your American dream into a serious nightmare. So take control of your destiny today and book your consultation session now. You will be glad you did. All righty. Thank you so much. That is really as much as we can cover today. We are already way over our allotted time slot, which is 2 hours. So I want to appreciate you for joining the call today. Thank you so much, Okoyemi, for the hard work on this show. Thank you, Samuel, for the unrelenting research. Of course, thank you so much, Madam Grace Okafo, my special person, for the research and collation that you guys do. Hopefully, we'll see you guys next week. Stay safe, stay informed at home. Get a lawyer. Don't let the crisis become real before you look for a lawyer. And talk to a lawyer before immigration knocks on your door. Call me, banwolaw.net/consultation, or get a lawyer close to wherever you live. If you don't want to call, we represent clients nationwide. What you cannot do, knowing that your immigration status is not solid enough, what you cannot do is just be waiting until it becomes a crisis. That will be a disaster. And finally, if you ever get into a criminal situation, whether you're a criminal or not is irrelevant. If you ever got arrested, maybe your wife called police, maybe police pulled you over, whatever it is, it does not matter whether they dismiss the case against you. Immigration can still use it against you tomorrow. That's why if that ever happens, definitely you need to talk to an immigration lawyer. if you're going to take a plea, don't take that plea unless your criminal lawyer told you that they have already consulted with an immigration lawyer and that is a good plea to take. Or unless your criminal attorney is also practicing immigration law. There are immigration consequences for every case right now. So you don't want to plead. I don't care if you didn't go to jail. It can prevent you from ever becoming a citizen later. So you don't plead without knowing the immigration consequences of your plea. That's my final advice for the day. Thank you guys so much for watching, and we will see you on the next edition of this show. Good night.